Tagat kora chita kwalanjini tangot the corner office in Kas TV betunatan barai ni ko kingalali ngale katanchi tinyiga ka somanet missing in a legal profession or not ngimitan ko bot professor and ko CEO secretary and CLE Kenya Professor Jack Mwimali ne ako bit koro ko missing in ko indan ke bertanatan taya ke bertanatan ne boyang again gun ke miten ke bertan ne bo welcome back, Prof. And looking at the failures, I know when you look at different professions, sometimes there's an upward trajectory, sometimes there's a downward trajectory. What does the council do about it?
Thank you very much for that question. Actually, it has been a vexation on council. We are blasted both ways. If they are seemingly, and I'm using the words cautiously, low performance in the by-exam will be blamed, especially by the candidates and their sponsors, on deliberately failing the students. It's like we are gatekeeping and we do not want them to join the by-exam. On the other hand, when there's very good performance, I remember last September we had more than 920 advocates that were admitted by the Chief Justice to the bar. And of course, the debate online was, how do you train all these? Where are they going?
Them, yes.
And therefore, we find ourselves in a situation of do you are damned, do not do you are also damned.
Yeah, damned, yes.
Our response in terms of performance, first of all, is that a student who prepares well will always pass. We have no intention whatsoever to prevent those who qualify from being advocate. In fact, it was aptly captured by the Chief Justice during that admission in September that if you have 1,000 well-qualified individuals who have been trained, who have been examined, who have passed, what do you do with them? You cannot just say because the profession is full, we cannot admit. You will admit all of them. As long as you are trained, you are examined, and you are found to be fit, we will allow you to graduate. In fact, as I have indicated, you see the process that we do through the examination period is so rigorous that it is almost impossible for you to be deliberately failed. Because you'll have a setter, you'll have a different examiner, you'll have a moderator. At least within those framework, you'll have captured where there's a problem. Beyond that, we also have a possibility of remarking. And again, we bring in totally new people to remark. If you feel that you must have done well and you failed. In many cases, you'll find that the marks are either the same or take or give, 5, 3, 2, 1, yes. Within the human level of understanding, some of the law questions are very objective. So I may have felt that you didn't answer sufficiently, somebody else feel. But in many cases, you'll find it's within a very limited scope. But we are not saying that we require them to be that. We normally just do our internal assessment of during remarking, for example, what was the highest score that was given in terms of the difference from what he initially scored. And that then helps us to know if our quality system at the time of marking is working. And that then helps us to mitigate situations of failure of those students. Number 2, and this is very critical, we require a student to do 9 papers within a year. Normally, the pass rate per paper is 50%. As a student, if I come in and of the 9 papers, I am able to clear 7 or 8. The question we normally ask, have I failed? I have not been able to clear 1, I have cleared 8. Or have not been able to clear 2, I have cleared 7. Have I failed? And there's various circumstances that may have occasioned me to do poorly. Maybe I didn't anticipate what was examined. I may have been sick. I may have panicked. We also give an opportunity for that student to recite that paper so that they are able to make up. And if they recite the papers that they have failed, ultimately they are admitted. And that's how we get to the 900 plus. It means we have a process that clears the system. But one thing we want to ensure is that we will not pass you for this because we are under pressure and the students are rioting or going around. We want even yourself as a qualified advocate to have that confidence that I was able to sit and by merit to pass the bar exam, and therefore if I go to court to represent a client, I have every ability because I have been examined and I have been found to be very qualified. And in many cases, I even ask those parents that want to help or assist their children to pass. I tell them, you see, the best assistance you give them is the encouragement to do. Because if I assist you and fraudulently you get into the system, then it means even as an advocate, you will be susceptible to corruption. Because you know there is a shortcut of doing things. If I can't represent my client sufficiently, I'll probably be looking for the contacts of the judge to see if I can. So let them go through the process. And the process we examine at CLE is the same challenge they'll find in practice. You will not always win your cases as an advocate. There are those that will fail. Not to mean that your case was deliberately or in any way maliciously lost. You see, everybody has a right of representation. So however weak the case, an advocate will still take it. So if you're an advocate that must pass at every stage, it means even when your client's case is weak, you'd want to influence it to have you have 100% win rate. I recently had, I think it was last year, when a quack was said to have won all the cases, I think 24 cases that they represented.
That's a big story.
The question is it fair administration of justice? Because in any case, there are two parties, isn't it?
Yes.
And one party must lose. Not necessarily because he was poorly represented. It's maybe because their case was weak. The law was not on their side. The facts were not on their side. So even as a practitioner, and I had the privilege of practicing for about 15 or so years, there are cases I lost. There are those that I won. It is the nature of life that you will lose in some, you will win in that. I was in college for 13 years, undertaking law. And I tell my students, the people who interact with me, that within the 13 years, there are those who are my colleagues who took 6, 7, 8 years. They had the same qualification as I. The fact that I took longer, does it mean I'm a weaker person? It doesn't mean so. An example of pilots who, during those days when there was no piloting school in Kenya, went to the US to train. Others, because of financial ability and even interest and skill, within 3 years, they had learned how to fly. They had accumulated the flying hours. They came back and were employed as pilots in KQ and in other airlines that went through the region. Others took about 7 years, 8 years. Maybe they were slow in understanding. It took a bit of time for them to master. But in the 8 or 9 years, they came back and were pilots. By now, 20, 30 years later, they're very good pilots. Nobody would be asking you how long did it take for you to train. It would, are you a competent practitioner? And for me, that rigor of ensuring that by the time I pass through that process, I have the qualification is very critical.
Very, very critical. Thank you so much, Prof. And for the interest, because of the interest of time, maybe you can talk to us about the ATP. I know most people also wanted to understand and get to know more concerning it. Yes.
The ATP is the exam. The ATP is the Advocates Training Program,
Yes.
which I've said is done at Kenya School of Law. You must apply to us to certify ourselves, because we have that mandate that you have the qualification to join the Kenya School of Law. And then, of course, the training normally starts at around January and ends in September, because October, November, because in November we then do the examination, the first set of examination. And we have deliberately, because again, you may be constrained, some are adult students, candidates. You may not have sufficient time from work to do your exam in September. We allow them in April to do another set of exam, either as a receipt or even a first attempt. We have a situation where CEOs have done the by exam even as they have worked as CEO. I remember a case of a colleague of mine who said they were deliberate. They knew they cannot do all those exams in one sitting. They chose to do 5 exams in November, and then they came for the remaining 4 exams in April, and they were admitted in the September the admission group. So we are able to facilitate them, and we are able to allow you to register for the number of units you feel confident to do. And if you fail, then you will have the possibility of taking 2 intakes. Let me hasten to say that we cannot, and we have seen from experience, continue to allow people to retake those units as many times as possible. The reason being, the law keeps changing. If you were trained with me in 2003 when I took my undergraduate, and you started your bay exam in 2004, by now the law is not the same as we were taught in 2003, 2004. So if we allow you to continually just recite, then we'll not also be doing justice to the system, to legal education. So in the new regulations, what we are proposing is that if you sit the bar exam, you will have up to 4 attempts.
4 attempts, yes.
You do your first attempt and then 3 more attempts for that unit. If you fail for that unit, it's very likely that we will allow you to go back to do that unit. To just that unit. So you go to the School of Law, do that unit, and then we allow you now to sit that exam, so that we don't have a situation. And if you have failed 4 times, it may be that you have not mastered that area. But number 2, after 5 years again, the system would have drastically changed. So after 5 years, you'd have had quite a number of attempts to sit those exams. Then we will probably discontinue you. It doesn't mean that we have locked you out. It means that if you want to still be a lawyer, and there are those who are very resilient, you can then go back to the Kenya School of Law, register, because the system of law now would have changed. Register and start afresh the process, so that we also have a closure. Otherwise, we have had situations, including now, where a person who was trained in 1998 comes and say, I failed a unit in 1998, I want to be allowed to do that one unit. Those units, of course, are not on offer. The syllabus, the curriculums, the curricula has changed. And yet, you are requiring us to, in those situations, maybe it may be more prudent for you to just go and redo the ATP, so that even as you study, you acquaint yourself with the current status of law.
On the law, absolutely. And I'm saying we are really out of time, and I promise we will come back again some other time.
You are welcome.
So that we explore more, because the legal matters is wide, so huge. You cannot just wide it up on one sitting. On your parting shot, Professor, from where you sit again, how do you see the future of the legal profession in Kenya?
I see a bright future. In fact, I have been following performance of our students from Kenya in moot court competitions in other parts of the world, in Europe, in the US, in South Africa, and they have been doing extremely well. Of course, it's the nature of a system that you will have very, very brilliant minds. We'll have average minds. You may have those who are not so good. And those that are not so good, it doesn't mean they're hopeless.
Yeah.
Again, the example I gave of the pilot, I may have been trained for 7 years to become a good pilot. You need to have the motivation to join the profession. And of course, you need to also commit yourself. Don't take shortcuts, just do what is required of you. And I can guarantee you, where we are seated, our concern is purely on quality. To guarantee the public that those who are being produced meet that quality. And we have every faith that our students are going to excel. Of course, there are those who complain that the quality of legal education has reduced. The same concerns when I came back in 2003 was there, that we need to now subject them to more rigorous program because the quality of education has gone down. More than 23 years later, we are still saying, and now us whose quality was being questioned in 2003 are the ones that are questioning those who are coming now.
Those are coming in, yeah.
As long as we put the infrastructure in place, for me, I have no doubt that we have a very bright future practitioner. And as I've indicated, we are even expanding the scope of training. We are now not just insisting on Commonwealth. We want to see you being able to practice even in a Commonwealth country by ensuring that the training in Kenya adapts to the universal reality. Thank you so much.
Thank you so much, Professor, for your time, and I know you have a busy schedule. We really appreciate for granting us this interview. Thank you so much. No, jita kwala jina tanga igas ko angala kitinye ga ka somanet missing kitinye legal matters gimiten ko botam professor and go secretary of CEO Jack Mwimali and ko television council not and about CLE Kenya. We are talking about you to kinta ne beta brand the corner office and cast TV kana nyun ko Stanley Bore. Sai